Hello, I'm attorney Vince Davis. Today we're discussing critical updates to California family law that every resident should know. The legal landscape in 2024 and 2025 has seen significant shifts, impacting everything from custody to property division. Let's start with child custody. The central pillar remains the best interests of the child, but safety is now prioritized more than ever. Peekes Law, effective in 2024, restricts judges from ordering children into unregulated reunification programs that may be harmful. It also mandates domestic violence training for judges and experts to ensure a trauma-informed approach in the courtroom. California has expanded the definition of domestic violence to include coercive control and financial abuse, not just physical harm. Effective January 2025, courts must also consider a parent's illegal access to firearms during emergency custody hearings. These protections ensure that your child's environment is truly safe and conducive to their long-term well-being. Now let's talk about child support. September 1st, 2024 marked the first major revision to the support formula in decades. The new K-factor formula generally results in higher support orders to better reflect the modern costs of child rearing. The income cap for standard calculations has risen to $35,000 per month, capturing more of the parent's actual wealth. For lower-income families, the law now right-sizes orders by tying adjustments directly to California's minimum wage levels. Additionally, child support for disabled children can now be directed into special needs trusts to protect their benefits. Expenses for childcare and medical costs are also now more likely to be allocated proportionally based on each parent's income. Transitioning to the divorce process, California remains a no-fault state, but procedural updates are simplifying the filing experience. Starting in 2026, couples can file joint petitions for dissolution, eliminating the adversarial requirement of serving one another. This is designed to reduce conflict and encourage a more cooperative approach to ending a marriage legally. However, remember that at least one spouse must have lived in California for 6 months and in the county for 3 months to file. There is also a mandatory 6-month cooling-off period from the date of service before a divorce can be finalized. During this time, both parties must complete preliminary declarations of disclosure outlining all assets and debts. Failure to accurately disclose assets can lead to severe sanctions, including the court awarding 100% of a hidden asset to the other spouse. This brings us to property division. California is a community property state, meaning all marital assets are owned 50-50. Assets and debts acquired between the date of marriage and the date of separation are generally split equally by the court. While every individual item isn't always split, the total value of the community estate must be divided equally between spouses. Separate property, assets owned before marriage or received via gift or inheritance, remains the property of the individual spouse. But be careful. If separate funds are commingled in joint accounts, the burden of proof lies with you to trace those funds back. Complex tracing often requires legal expertise to ensure your separate interests are preserved during the division process. In many cases, student loans are assigned to the spouse who received the education unless the community benefited significantly. Spousal support is another key area. Marriages lasting 10 years or more are considered marriages of long duration in California. In these cases, the court may retain jurisdiction over support indefinitely, meaning it could last until death or remarriage. Understanding the 10-year rule is vital for your long-term financial security and post-divorce planning. Even your pets are now considered with more care. Judges can consider their well-being when granting ownership during a divorce. The date of separation is also critical, as it stops the clock on the community estate. It requires a clear final break. Evidence of this intent to separate is essential for correctly dating the end of the community property period. Navigating these intricate laws requires an attorney who understands the nuances of the California Family Code. With nearly 40 years of experience, we have handled thousands of cases across the state, from simple to high conflict. We are committed to providing you with the advocacy and clarity needed to protect your future and your family. Don't leave your case to chance. These new laws can significantly impact your rights if not handled correctly. Whether you are facing a custody battle, a complex divorce, or support issues, we are here to help. Our team is ready to listen to your story and develop a strategy tailored to your specific needs. Call our office today to schedule a consultation. Let's discuss how we can achieve the best possible outcome for you. Reach out to us at 888-888-6582. That is 888-888-6582. The phone number again is 888-888-6582. We look forward to being your voice in the legal system. Thank you for watching.